Welcome back to another explainer. Today, we're diving into the darkest, strangest justice ever recorded. I mean, we're talking about a chapter of history so bizarre, so incredibly macabre, it honestly feels like it was ripped straight out of a gothic horror novel. We're looking at an era where animals weren't just, pets or livestock. No, they were literally treated as legal defendants in crimes against nature. It's this wild intersection where human desire and historical brutality collided in some truly terrifying ways. Let's get right into it.
So, can an animal actually be guilty of murder? Well, in our modern world, the answer is an obvious no, right? Animals act on pure instinct. But to our ancestors, an animal could absolutely be a murderer. They could be witnesses. They could even be willing accomplices in a crime. To really wrap our heads around this totally alien mindset, we actually need to ground ourselves in the physical reality of these acts first. And to do that, we're going to start by looking at a genuinely shocking tragedy from our own time. Section 1. A deadly modern case and the Enumclaw tragedy. Okay, let's dive into this. To understand the sheer madness of the historical cases, we have to start with perhaps the most infamous modern case of its kind. In July 2005, a 45-year-old Boeing engineer named Kenneth Pinion, he went by the alias Mr. Hands online, was anonymously dropped off at a hospital in Enumclaw, Washington, and he was already dead. The investigation revealed that Pinion was actually part of a secret group of men who met up at a rural farm to engage in sexual acts with horses. The physical reality of this act was, frankly, just way too much for the human body to endure. Pinion had engaged in receptive anal sex with a stallion, and he died of acute peritonitis caused by a fatal perforation of his colon. The animal had, in a very physical, literal sense, killed him through severe internal injury. So the crucial point here is how our modern legal system actually responded to this. Back when this happened in 2005, zoophilia was actually perfectly legal in Washington state. Crazy, right? Because of this, the stallion was left completely unharmed by authorities, and Pinion's surviving associates were initially only charged with trespassing. The animal was recognized simply as an animal, completely devoid of any legal guilt or malice. And as you'll see, this is a fundamental night-and-day contrast to how our ancestors would have handled the exact same situation. Now, the sheer gruesomeness and massive public shock of the Enumclaw case did prompt the Washington state legislature to take immediate action. They rapidly passed a bill making bestiality a Class C felony. So the law changed, but the modern legal boundary remained completely intact. The humans were held responsible, not the animals. History, however, well, history tells a very, very different story. Section 2. The descent into historical madness and centuries of bizarre trials. You see, these bizarre trials weren't just some brief fad or an isolated panic. If we trace the timeline, starting from the Supreme Court of France in 1466 with the Mayor of Corbeil, straight through to colonial America and beyond, it reveals a total obsession that spanned centuries and continents. Literally thousands of animals were put on trial throughout history. A rare few are remembered because their involvement in these acts led to the agonizing deaths of their human partners, and almost always the animals themselves. Now, what's really interesting about this is the driving force behind it all, a concept called natural malice. This was a medieval legal framework that treated animals as active participants, completely capable of actual evil intent. It's wild to think about. For instance, back in 1606 in Chartres, France, a man named Guillaume Gaillard was caught in an act of sodomy with a dog. Under this framework of natural malice, the mayor of Chartres convicted Gaillard, and the punishment was absolute for both of them. The man and the dog were actually sentenced to be hanged and strangled on a gibbet together. No exceptions. And this mindset even crossed the Atlantic right into colonial America. In 1662, in New Haven, Connecticut, we find the deeply chilling case of William Potter. Now, Potter was a 60-year-old pillar of his church, really noted for his deep piety. But he carried a dark, dark secret that spanned 50 whole years. He engaged in what they called damnable bestialities. Get this, his own wife actually caught him in the act with a dog and kept it a secret for an entire decade. But when the law finally caught up with him, the justice handed down was just breathtakingly cruel. Section 3. Condemned to the flames and the macabre punishments. These definitely weren't your simple, everyday executions. They were these highly theatrical, ritualistic displays of state and religious power, specifically designed to visually cleanse the community. Let's walk through the horrifying steps of this justice. In William Potter's case, he didn't die directly at the hands of his animals, but he was absolutely condemned because of them. Up at the gallows, the state forced him to watch as his animal lovers, we're talking a cow, 2 heifers, 3 sheep, and 2 sows, were all slaughtered right before his very eyes. Only then was he hanged. And in other cases, like the 1685 case of a tailor in Striga, it was somehow even worse. The tailor and a mare were both burned to death, with the court explicitly making sure the human's body was placed underneath the animal's body in the fire. It was this final macabre gesture of ultimate debasement. Section 4. The Theology Behind the Trials and Rituals of Justice. As a modern viewer, looking back at these staggering executions, you really just have to ask, why? Well, to the people of the Middle Ages, this wasn't madness at all. They drew their legal precedent directly from the Hebrew Bible. Specifically, Exodus states that if an ox gores a man or woman to death, the ox shall surely be stoned. The logic was clear. If an animal causes a human death, the animal itself must be punished and destroyed. Medieval lawyers took this ancient text and expanded it into a completely comprehensive, unyielding legal doctrine. They expanded it into what they actually called a de facto insurrection. Basically, any act of bestiality, or really any animal involved in a human's death, was viewed as a literal uprising against God's hierarchic order of creation. The animal was literally viewed as an incarnation of a demon, or just completely diabolically tainted. And the lawyers genuinely believed that if they left this guilty, tainted animal alive, it would bring literal pestilence or demonical infestation to their entire land. So these executions were, in their minds anyway, an absolute matter of public health and spiritual survival. And this brilliantly illustrates how they took this logic to absolute, staggering extremes. To hold an animal legally and spiritually responsible, they had to personify them. Animals were literally jailed right alongside human prisoners. Sometimes they were even dressed in human clothes, given waistcoats and gloves before being marched to the gallows. There's no way, right? But it's true. They were even provided defense counsel at the community's expense. It was just this complete, totally absurd personification of the brute, all to somehow justify holding them accountable for their so-called crimes. Section 5. The Shift to Reason and the Enlightenment. Let's move on and see how this builds, because as the 18th century Enlightenment finally took hold, these bizarre trials, thankfully, began to fade into history. One of the last and frankly most surprisingly humorous cases occurred in France in 1750. A man named Jacques Ferron was caught with a she-ass. But this time around, the animal was formally acquitted of all charges. Why? Because character witnesses actually came forward and swore to the court that she was a virtuous and well-behaved animal who had been forced into the act. So the animal was actually spared her life. Ferron, unfortunately for him, was still sent to the stake. It really all comes down to a fundamental clash of mindsets. The Middle Ages saw natural malice, demonic infestation, and strict legal culpability in animals. Our modern mindset, on the other hand, sees biology, instinct, and a very clear boundary of human responsibility. Yet as that tragic Enumclaw case from 2005 reminds us so clearly, while our legal and spiritual understanding has definitely evolved, the stark physical dangers of crossing that boundary between human and animal remain just as real and absolutely just as deadly. History shows us time and time again that when the lines between human and animal are blurred, the result is almost always a tragedy of blood and fire. I want to leave you with a final, provocative thought to ponder as we wrap up this explainer. When we put animals on trial, when we dressed them in clothes and actually provided them with lawyers, did those trials raise animals to our level, or did we just sink down to theirs? Let me know your thoughts in the comments. And if you enjoyed this deep dive, make sure to hit subscribe for more. See you next time.